Top tips for getting sole custody in family court. Welcome, I'm Kyle Kaufman, attorney at HKK Law Offices. This is our YouTube channel. Thanks for stopping in. Hey, if you're a parent who's looking to secure sole custody, this video is packed with practical advice to help you prepare your case. So let's jump into tip number one. The foundation of your success in court is to do this: create a parenting plan that outlines exactly what you want. So, creating a parenting plan, think of it this way. It is like planning a vacation. Imagine this: if you were planning a trip, you'd ask yourself key questions like, who's going? Where are we staying? How much will it cost? How will we get there? And what will we do when we arrive? And your parenting plan is no different. It's your roadmap for your child's future, and it's crucial to get specific about your goals and how they'll be achieved. Let's break this down a little bit. There's some key elements to a parenting plan that you need to know about. When creating your parenting plan, write down exactly what you want in the following areas. Custody arrangement. Do you want sole custody or joint custody with the other parent? Sole custody means you'll make major decisions for your child alone, while joint custody means you'll share that responsibility. What about major decision making? Things like education, medical care, child care, and religious upbringing. What about the living arrangements? Where do you live now? Where will you live in the next 2 years? Where does the other parent live and work? And what are the household dynamics like? Write it down. Who lives in each parent's household? Are there child care arrangements needed? What about school and medical providers? What school will your child attend? Who are your child's medical providers? Have you thought about the religious preferences? Do you have a preference for your child's religious upbringing? Write it down. It's important to have a placement schedule in your parenting plan. What recurring schedule do you want for the week and overnights? And how will you divide holidays, time off of school? How will you deal with transportation and exchanges? Where will it occur? When will it happen? When creating your parenting plan, write down exactly what you want in the following areas. Custody arrangement. Do you want sole custody or joint custody? When you have sole custody, that means you'll make major decisions for your child alone, while joint custody means you'll share that responsibility with the other parent. What about major decision making? Who will make decisions for your child on education, medical care, child care, and religious upbringing? What will the living arrangements be like? Write down where you live now and where you will be living in the next 2 years. You want to write down where does the other parent live and work, and know what your work schedule is and when you're available for the child. Consider the household dynamics. Who lives in each parent's household? Are childcare arrangements needed for the child? And what about school and medical providers? What school will your child attend? Who are your child's medical providers? What are the religious preferences for your child? Do you have a preference? Discussing that and writing down a plan for that is important. What's really key is a placement schedule. What recurring schedule do you want during the day and overnight for your child? How will you divide holidays and school breaks? How is transportation and exchanges going to work? Have you thought about how placement periods will start and end? What time? How will transportation be handled? Where will the pickup and drop off occur? What about communication? Is the child allowed to contact the other parent when the child's in your care? And if so, how will that be done? Will the child have access to electronic devices to communicate with the other parent? You will also want to consider the safety concerns and write down this information. Has there been any physical violence directed at you or the child by the other parent? If so, what safety conditions need to be implemented? Consider evidence of endangerment to the child, things such as drugs, alcohol abuse, emotional instability, or mental health concerns, and write down the conditions that you'd want concerning those items. Now, once you've answered these questions and you've written them down, you'll have a comprehensive parenting plan. And this plan is more than just a document. It's your blueprint for success in court. It's a roadmap. And here's why that is so important. It gives you clarity on what you want for your child's future. It shows to the court, the guardian ad litem, and even the other parent that you're well prepared, you're serious, and you know what's in your child's best interests. The second tip is gather your evidence. To gather your evidence, you need to consider the information that you have that supports your position in your parenting plan. And let's take a moment to explore where you can find that evidence. Start by reflecting on the relevant stories that demonstrate what is in the best interest of your child. And this could include what your child wants, how well the parents cooperate and communicate, whether the parents support the child's wishes and each other's relationship with the child, how the child interacts with each parent, family members, and friends, the amount of quality time that each parent has spent with the child in the past. Think about the stories of evidence of drug or alcohol abuse, interspousal battery, or child abuse. Consider criminal convictions, significant others, the age or developmental needs of the child. And then you want to gather the corroborating evidence that will support these stories, these things that you know, okay? And consider these sources for your evidence: pictures, recordings, videos, documents such as emails and text messages, social media posts. It could be records from professionals like medical providers, school records, police reports, or child protective services reports. My third tip for you is hire an attorney. The third tip is hire an attorney. An attorney is trained in the law and knows how to apply the facts to your case to it. They'll help you present your evidence effectively and ensure that it is admitted in court. An attorney can also identify and prepare witnesses, funnel factual information to the court, guide you on the applicable law. Right? Without an attorney, the burden is on you to navigate these complex requirements. Prepare your case, present it to a court, get it into evidence. And that's a daunting task, and it can impact the outcome of your case. My fourth tip for you is file a petition, and in some states it's called a motion. By filing a petition or motion, you are requesting sole custody, and that's the official start of the lawsuit. Once it's filed, you have to serve the other parent with the petition, notifying them of the legal action. If that parent doesn't respond, the court may grant your request by default. This step puts the process in motion and ensures that the other parent is legally required to participate in the action that you have now started. The fifth tip is request information from the other party. By requesting information from the other party, you gather evidence, and this process is called discovery. And you want to gather the same evidence that you're preparing in your case. So ask the other parent for documents, records, communications that are relevant to your case. Be persistent in your requests and follow the legal guidelines for discovery. An attorney can assist you in navigating this process effectively. My sixth tip: work well with the guardian ad litem. A guardian ad litem, also known as a GAL, represents the best interests of the child, not either parent, and it doesn't represent the child, just their best interest. You need to establish good rapport by being respectful, honest, and prepared. Be ready to share relevant evidence. Talk to your attorney, though, before you meet with the guardian ad litem. Listen carefully when you do meet with the guardian ad litem. Dress professionally, be on time. The guardian ad litem's opinion can have a significant impact on the court's decision, so maintaining a good rapport with the guardian ad litem is important. Tip number 7, attend all the court events. Demonstrate your commitment by showing up to every hearing, status conference, pretrial meeting, and while you're there, make sure to follow these guidelines. Be punctual, dress professionally, stay attentive, don't be on your phone, speak only when called upon, follow your attorney's advice. Make a good impression on the judge and other participants, and by doing that, you can significantly influence the outcome of your case. My 8th tip for you is to present your case clearly. Do it in a simple fashion. Think of your parenting plan as a menu. Lay out your request clearly and explain why they're in the child's best interest. Hand that to the court and provide evidence and testimony to support your claims in your parenting plan. That makes it easy for the judge to decide in your favor. I have a bonus tip for you guys, and my bonus tip is this: don't leave out the facts. Let me say it again. Don't leave out the facts. Judges are fact finders, and they base their decisions on the evidence that's presented, the facts. And if you fail to provide critical facts or challenge the false ones presented by the other side, the court's decision may not reflect the reality of your case. Be thorough and transparent. The court's decision is only as good as the facts it relies on. All right, guys, those are my tips for how to obtain sole custody. Remember, preparation, persistence are your best tools for success in family court. Thanks for watching. I'll see you next time. Take care.